We are here for oral arguments in case 19AP0028, State of Ohio versus Kelly Patton. Each party will have 15 minutes to present its argument. The appellant may reserve up to 5 minutes for rebuttal. If you wish to reserve rebuttal time, let me know before you begin your argument. I'll do the best I can to keep you apprised of when you're getting close to your time. Doesn't apply here, but I'll say it anyway. You should not use the names of any children or minors, and don't use the names of victims during your argument. Instead, just please refer to the individual either by initials or boyfriend or whatever you feel fits. We have read your brief. We are ready to proceed when you are.
I may please the court, Your Honor. It's David Gedrock for the appellant, and I would like to reserve 5 minutes, or as much time as left after I'm done with my initial argument.
All right. You can go ahead.
Ready? Thank you. All right. Your Honor, in this case, both parties has discrepancies in their stories, versions of where they said or didn't say different facts to the police earlier or in court for the first time. But certain truths did come out. Number one, the defendant did not owe $10,000 to the IRS. The tax records showed that the alleged victim knew that was true, and that the alleged victim was the one that paid the taxes for both of them. Secondly, a certain truth came out was her hand was speared to the bed. There's no question about that because you have the cutting from the bed. If, in fact, she had attacked him, as he alleges, he was asleep. He was in the bed. There was nothing preventing her from plunging the knife into his neck as opposed to just scraping it, as he testified. Had she plunged that knife into his neck, the doctors talked about he could have suffered vascular injury and or structural damage. But again, he didn't. He was asleep. He would have never seen it coming. Nothing would.
Counsel, wasn't it dark in the room as well?
That's correct. Even further evidence, he would have not seen it coming. So
no, but she just might have missed her mark.
It's possible, but she also had the opportunity to strike a fatal blow, and she only cut him, sliced him. There's a big difference between stabbing down and slicing. I mean, if she stabs down, there's a very good chance she's seriously going to hurt him. Instead, he only suffers a superficial penetrating injury. The doctor testified it was less than a centimeter. He has cuts and scrapes. However, his injuries are more consistent with a woman swinging a knife who has just suffered severed tendons, nerve damage, and loss of feeling. But defense counsel did not make this argument. Additionally, my argument is defense counsel should have requested that the trial be continued, so the new law about self-defense, which was only about a month away from being implemented, would have been applicable to this case. And if he wasn't going to ask for continuance, I think counsel, in an attempt to do an efficient job, should have requested the job give the jury instruction in anticipation of it coming down the road. Had that happened, this case would in all probability have turned out differently. The burden of proof would have shifted. Under the old law, she had the burden of proving that self-defense was justified. Under the new law, she would have been innocent until the state proved that the actions were not self-defense. Again, the burden would have shifted.
Except you acknowledge that the statute does not expressly make itself retroactive.
No, I agree with that. He could have asked for a jury instruction. The judge grants it, doesn't grant it. Then he has an issue on appeal as to whether he should have. But failing to ask for the jury instruction, the only issue he has is plain error. He could have set this thing up for a much better position for his client. Under the new law, it's highly unlikely the state wouldn't be able to prove the knowingly element of the felonious assault charge and or the domestic violence. In self-defense, Your Honor, the goal is to attack, to stop the attack and prevent it from being inflicting upon you. If somebody gets injured in the process of the attack, that happens. To take an argument out of tort law, if you're the one who starts the confrontation, you generally can't complain you got injured in the result. had the new law been applied, there's a good possibility she would have been able to raise reasonable doubt. The state would not have met its burden. Also, reasonable doubt would have existed had the defense counsel made the argument about her hand, that it suffered damage. Because he didn't make this argument, the jury was instructed that she had the burden of proof, and they didn't believe her. But the burden should have been on the prosecutor to prove that the actions were not in self-defense. Especially, again, when you couple it with the injury to the hand, the fact that her hand was speared to the bed, and she suffered nerve and tendon damage, and she still has flexibility issues, and she still has to have a second or third surgery.
Well, counsel, how does the DNA evidence that the state presented fit into your theory about the hand?
Well, the DNA evidence, as I recall, shows that there was both parties had touched the knife, although they couldn't really identify there was male DNA, whose DNA it was. Her DNA is found where you would expect it to be, on the blade and on the handle, if she is in fact going to use the weapon to defend herself after it has been plunged through her hand. So it's consistent with my argument too, that this argument should have been made. Let's compare the injuries. A person asleep, unaware of what's going on, only suffering superficial injuries when there's nothing to present the infliction of a death blow, versus a person suffering superficial injuries from a woman who's wielding a knife in her hand, a hand that she had to pull a knife out of, and she is right-handed too, that was established, that has suffered tendon and nerve damage, and to this day still needs surgery.
Well, counsel, let me ask you this also. You've mentioned several times death blow, and she could have struck in a place that would have killed him. She wasn't convicted of that. I think that was dismissed early on. It's causing serious physical harm, which, quite frankly, anything that could leave a scar can be serious physical harm.
No, I agree.
You need to try to inflict a death blow?
No, I'm just using that as hyperbole to make the point that if she was being charged with a serious felony, that she could have gone beyond that had she had the opportunity to do so. There was nothing preventing her from going beyond that. I'm just trying to make the point how lucky or how inconsistent it is with what supposedly happened to him and what could have happened to him. I'm wrapping up here on my first part. Defense counsel should have...
You still have a good 3 minutes on your first part.
Okay, good. I should wrap that up then. Thank you. All right. Defense counsel should have asked for a continuance so that the self-defense law would have been effective during the trial. I've appeared before Judge Weiss. He's a reasonable man. I think he would have entertained that motion. I can't say for sure, but I've appeared before him. He's a reasonable man. If the court denies a continuance, then ask that the new law be included in the jury instruction. I already mentioned this earlier. If the jury instruction is denied, then it's error. If he never asked for it, then it's the only argument he has, it's plain error. And I was also, another thing defense counsel should have done was sought to continue the sentencing until the new law had been in effect, and possibly make an argument that the client should have had an option under what law she should be sentenced under. But instead, he waited past the 14 days to ask for a new trial. So that was denied too, because he didn't show any reason why he should have been allowed to delay it, file his motion past the 14 days. For those reasons, Your Honor, we think the defendant should be granted a new trial. And I'm going to stop here and save my final minutes for my final. Thank you.
All right. Ms. Euler, whenever you're ready.
Good morning. Thank you, Your Honors. May it please the court, counsel Andrea Euler for the state of Ohio. To start with the credibility determinations that Attorney Gadrock and Ms. Patton raised in her third assignment of error with respect to the manifest weight, Ms. Patton argues that her convictions are against the manifest weight of the evidence because, in her opinion, the victim offered an incredible version of how the assault took place, while her version, quote, was logical and therefore the only credible explanation of the quote, of the event, end quote. In reality, The victim's versions of the events and throughout the ordeal was detailed and consistent, while Ms. Patton's versions, plural, were inconsistent and illogical. The victim's versions of events is best summarized as follows, as set forth in the brief, but the evidence adduced at trial construed in the light most favorable to the prosecution, but it showed that while JT was sleeping, Ms. Patton knowingly stabbed him in the neck mere centimeters from vital structures. When JT awoke and asked Ms. Patton to turn the light on because he thought she'd accidentally cut him with a ring, she again stabbed out at JT, this time slashing the top of his left forearm as he reached up to feel his existing neck wound. Sensing danger, JT attempted to make his way out of his bedroom when he heard Miss Patton make an oomph sound, and he was sliced through his fingertip and fingernail. He escaped to the stairway where he grabbed a hold of Miss Patton's hands, and that's where he felt the serration of a knife blade. He escaped down the stairs to the front door where he felt a sharp pain below his shoulder blade and above his buttocks as he fumbled with the lock on the front door in his bid to flee the house. His version of the event, singular, was consistent. He gave this version one time, was able to put it in chronological order and even more detail than I set forth there. But Officer Styler had testified at trial that JT was able to give his version in chronological order just once. He never indicated that he did not remember what had happened. Ms. Patton, on the other hand, was never able to provide her version of the events in chronological order, and she consistently indicated she could not remember things. Officer Styler testified Ms. Patton advised him that she recalled approximately 50% of what had happened, and she would become extremely emotional, accusing him of not believing her. Whenever he would question her version of the events or ask more difficult questions. He testified Ms. Patton would modify her answers whenever he expressed any doubts as to her explanation. And as counsel indicated, it was known that Ms. Patton received a stab wound through her hand at some point during or after the assault. But when and how it happened, Ms. Patton could not even say where it had happened when she spoke with Officer Styler. After a lot of questioning, she indicated she was stabbed while she and JT had struggled in the bed. And when she spoke with Officer Shane, Officer Shane testified he had to keep asking Ms. Patton questions in order to obtain information from her. She could not explain how the series of events occurred, how one event led to another, but she did recall that the next thing she knew, she had a knife in her hand. It was at trial when Ms. Patton's story became much more detailed. She recalled awakening to the sensation of metal across her chest. JT allegedly had his hand and a knife up her shirt and he was straddling her. The hand up the shirt detail was a new detail. Likewise, she suddenly recalled pushing, kicking, shoving, and yelling. She testified that after some fighting, she was able to get a hold of the knife and she started swinging it to get JT away from her. And then somehow he got a hold of the knife and she felt really, really bad pain in her hand. And that's when she realized that her hand was stuck to something and she pulled her hand free. Suddenly she was able to detail when she pulled the knife out of her hand, what she did after she pulled the knife out of her hand. These were details she was never able to tell the officers prior to trial. Now, when we get to the DNA evidence, it was mentioned, that both parties were on the knife. Well, the evidence at trial showed that Ms. Patton stabbed JT with the folding knife, and she stabbed her own hand with the kitchen knife. The DNA profiles were collected from both the folding knife and the kitchen knife. Ms. Patton's DNA was found on the handle of the folding knife just below the clip, the hinge of the knife where the clip is held on, and along the back ridge of the knife, so on 3 places. JT's DNA was excluded from those places. His DNA was only identified on the blade of the knife, along with Ms. Patton's. With respect to the kitchen knife, both Ms. Patton and JT's DNA were located on the blade. Only Ms. Patton's DNA was located on the blade of the knife, but both parties, both the victim and Ms. Patton's DNA was on the handle. However, it was the kitchen knife, and it was a a lower DNA amount. So the arguments that counsel is raising, having reviewed his brief, he's alleging that counsel didn't make this argument about her wounds being consistent with someone who had just had their hands severed and the slashing, that I didn't take that away from counsel's brief, don't recall that argument. And I know that I agree it wasn't raised at trial. So overall, with respect to the manifest weight of the evidence, the state presented overwhelming evidence, and we know that when it comes down to a matter of credibility, that's for the trier of fact to decide. And in this case, the jury clearly did not lose its way when it found Ms. Patton guilty of the offenses she was charged with. With respect to the ineffective assistance of counsel claim, I guess, stepping back, it was on February 28, 2019, when Ms. Patton was convicted of the 3 of the 4 counts sought by the state, being the 2 counts felonious assault, 1 with a knife, and the domestic violence. These offenses were committed on or about May 1st, 2018. It was on April 9th, 2019, the day before she was sentenced, and more than 30 days after the jury had rendered its verdict, when Ms. Patton filed her motion for leave to file a motion for new trial based on the amended 290105, being Ohio's self-defense statute. We know that 290105 was amended March 28, 2018 to change the affirmative defense of self-defense by shifting the burden of proof to the state. And it's true that the change in law now requires the state to prove that the defendant did not act in self-defense where the defense could reasonably be found to apply. In this matter, Ms. Patton did receive a self-defense jury instruction. But Ms. Patton argues that her counsel was ineffective for failing to ensure that she was able to avail herself of the newly amended 290105. She has pointed to no case law to support her contention that her trial counsel's failure to ensure that her trial occurred on or after March 28, 2019 amounts to ineffective assistance of counsel.
Counsel,
Yes.
what would be the reason for not asking for a continuance? So wouldn't it always be better to have the state have to prove you guilty than you have to prove yourself not guilty?
In this matter, I'm not sure. I didn't calculate the speedy trial time. I know that counsel in the appellate brief hasn't set forth an argument as to if there would have been sufficient time to have the trial past the March 28th, 2019 date. In the motion for new trial filed by trial counsel, it did indicate that there would have been time, but for the vagaries of the court calendar. And so I don't know. I assume that there could have been time, but it's working with a lot of assumptions, knowing that trial counsel, was aware that this statute was coming into effect. And I do believe that there's an issue. It's clear that 290105 as amended is not to be retroactive.
But it says it applies at trial, right?
And that's where, in all of the cases I was able to locate, all of the offenses had occurred prior to the date, and the trial had occurred before the date of the amendment. And so that could be an interpretation that as of the date of trial, as long as that's in effect, then it would apply. But I think it is something that defense counsel, the failure to move for a continuance if there are on no other grounds, I don't think that rises to the level of ineffective assistance of counsel. In this matter, as I stated, there's been no case law to support the contention that that failure to ensure the trial occurred on or after March 28, 2019 amounted to that of ineffective assistance of counsel, nor has she set forth any case law in support of her contention or counsel was ineffective for failing to prevail on its delayed motion for new trial. The Sixth Amendment right to effective assistance of counsel does not require defense counsel to file a motion for a new trial where any such motion would be frivolous. When defense counsel fails to prevail on what could be considered a frivolous motion, it simply cannot arise to ineffective assistance of counsel. Here, Ms. Patton's counsel filed her delayed motion for new trial because filed a delayed motion for new trial because that statute that she desired to avail herself did not become effective until 28 days after the end of her trial, 28 days from her conviction, and almost 1 year from the date she committed the offense. And I'll take this time to apologize for the error and misstatements in the brief. I noticed I said 30 days and more than 1 year, but I believe that the correct is the 28 days, and it was almost 1 year in this case. But the evidence, the facts of this case show that she simply would not have been able to avail herself of that 290105 amendment, and there's no case law to support that the failure of her counsel to make that motion when the statute wasn't amended for more than 30 days from the start of her trial, and it wasn't intended to be applied retroactive. There's nothing that would make it apply to her case. And the cases that I've cited in my brief that clearly state that the statute's not retroactive, none of them set forth the argument that Ms. Patton has advanced on appeal. But that still doesn't take away the fact that Ms. Patton is not entitled to avail herself of the amendment until she can show that her trial counsel committed error, or first was deficient, and two, committed error such that the outcome of the trial would have been different. She's simply, there's no ineffective assistance of counsel, and she's not entitled to a new trial. And I wanted to, on the part of, had a moment there when I remembered what defense counsel had stated, and we'll move on. Just for additional clarification as to, in the second assignment of error with respect to the insufficient evidence argument, in this matter, the same concerns, arise after asserting the victim in this matter lacked credibility, which would go to the weight of the evidence, not the sufficiency. Ms. Patton boldly asserts that her case should never have gone to the jury. And, to support a conviction of felonious assault, the state has to prove beyond a reasonable doubt one knowingly caused serious physical harm to another, or caused or attempted to cause physical harm to another by means of a deadly weapon or dangerous ordinance. We know that these elements have been met, as explained in the brief, as the evidence at trial, again construed in the light most favorable, showed that Ms. Patton stabbed the victim in the neck mere centimeters from those vital structures. The victim actually sustained stab wounds to his neck. The one to his neck required 4 to 5 sutures to the inside and to the outside of the wound. And the stab wounds required sutures to his left shoulder blade, a few inches above his buttocks, as well as the laceration to his left forearm and the slice through his fingernails. So overall, the defendant has failed to set forth any sufficient arguments that she had ineffective assistance of counsel. She failed to meet either of the Strickland standards. She failed to show that even if somehow she could have gotten a continuance, that it wasn't effective assistance that would result in her not getting that jury instruction. She's failed to show how the state failed to prove sufficient evidence, as there was no argument as to what was insufficiently proven. And so, walking through all of the elements of the offenses charged, the state met each and every one of its elements. Just looking through the testimony of the victim in this matter. And as to Ms. Patton's third assignment of error, her convictions simply weren't against the manifest way.
Gotcha. All right. All right. With that, your time is up. Mr. Gedrick, you'll have your full 5 minutes. You need to unmute. There
Okay,
you go.
I'm unmuted, thank you. All right.
All right.
insufficiency or ineffective assistance of counsel is when the performance of counsel is so serious that the counsel was not functioning as guaranteed by the Sixth Amendment. The error is made by counsel as a deprived file, and the defendant must show that there's a reasonable possibility that but for the professional errors, the results of the proceeding would have been different. I think we've proven that. I agree. I agree the statute was not retroactive. It did apply to trial, and there wasn't a problem with it. Even if there was, there's nothing that would have prevented defense counsel from filing a waiver so that we could have heard more time.
Is there evidence that the defense counsel even knew about the statute and the amendment, proposed amendment?
I can't say for sure. I can infer from the fact that he realized that he made a mistake when he filed for a new trial outside of the time, but I can't say for sure. I can't read his mind, and I'm not going to try to infer anything from there. But anyway, the point I'm trying. I'm sorry, sir. Go ahead, please.
No, you go ahead.
Okay. When you couple the argument that the new law should have been applied with the argument that the injury she suffered, or she suffered and the injuries inflicted upon the alleged victim, it's all consistent with somebody whose hand has been stabbed and who's had surgeries and who's had problems and still has problems today. If you're having problems with your hand, you're not going to be as effective holding on to it as you would have been before you had the injuries, which would explain why there were only superficial cuts that he suffered.
Well, let me ask you a question on that point. Attorney Euler indicates that argument was not raised at trial and was not addressed in the brief. Is that the case?
Well, I know it wasn't raised at trial, but I think I made the argument about insufficient, and now I'm fleshing out what I consider to be the insufficient argument. Ineffective assistance of counsel. That's what I'm flesh it out. So anyway, I'm wrapping up here. I'm sorry, do you have another question?
No.
All right. So absent the application of the new law in this case, if defense counsel had made the argument that the victim's injuries were consistent with that of a person who had her hand speared to a bed, he would have created reasonable doubt. He would have created a reasonable doubt argument that would have caused a reasonable jury to pause and consider the case from a different angle, an angle that would have caused the jury to consider the credibility of both parties. Instead, the jury lost its way, and the defendant was improperly convicted of a crime that she didn't do. And I'm done. Thank you for your time.
All right. Thank you both for your arguments. We will take the matter under advisement, issue a written decision in due course. It will be mailed to both sides. It'll be posted on our website and the website of the Supreme Court of Ohio. Next video oral arguments for the 9th District will be Tuesday, November 3rd. Both of you have a good day.
Thank you.
Thank you.